Hi everyone. In a few next sessions, we will be honing in on different types or categories of rights to get a better conceptual hold of what human rights actually are in practice. My approach will be hereby somewhat classical. So in this first video of 3 for this upcoming session, I'll be firstly talking about various general categories of rights before then moving on to address civil and political rights, and in particular the prohibition of torture, inhumane and degrading treatment in the second and third video respectively. Now let me start with an important disclaimer. As the 1993 World Conference on Human Rights final document states, human rights are in fact universal, indivisible, interdependent and interrelated. And human rights scholars and practitioners will tirelessly point that out when we talk about various categories of rights. There's a lot to be said, in fact, about each of these notions. They all have their own implications and own normative content. But to summarize it very shortly, the suggestion here is that it points out that you should not, in fact, if you can ever avoid that, weigh human rights against one another or try to prioritize them. It's a nonsensical exercise in a way, because really they do presume each other, they do reinforce each other. And especially if we consider individual dignity, autonomy to be at the heart of this whole endeavor, it is also not entirely clear why something should be prioritized over something else. Individuals are different, have different preferences, and therefore you get into a quite difficult and eventually troublesome discussion. So that's actually not the goal of this video or the general idea of categories of rights. Rather, what we're trying to do here is to get a conceptual hold of the various kinds of questions that arise with regards to different types of rights. It's not that one is more important than the other, but they do bring about different challenges. They're sometimes implemented differently, and therefore it does make sense to make some distinctions for the sake of our understanding. Now let me start very shortly with the distinction between individual rights on the one hand and collective or group rights on the other hand. In the previous clip, I addressed quite extensively the centrality of the individual, so it should have become clear by now why the notion of the individual is at the heart of human rights law and what that entails. At the same time, we have still the notion of group rights, and this sometimes creates confusions because in the first instance, you do have rights that individuals hold as members of a particular group. And here in the chapter, the notion of rights of minorities is mentioned, and that's obviously the most classic example. So for example, if you are a person belonging to a linguistic minority or an ethnic minority, a cultural minority, you have the right to, for example, enjoy the cultural rights that come with it, and are related, for instance, to the right to education, as an individual member of that community. That being said, there are collective rights properly speaking. And the most important example here is the right to self-determination that we addressed partly in the public international law course already. That is in fact a right of peoples, and that was particularly salient in the context of decolonization. However, there's also the rights, for instance, of indigenous people, which is slightly different, but which has been affirmed, for example, by the Inter-American Court of Human Rights, and which entails such a thing as the right to collective property or the right to effective participation in the use of land. We'll be addressing the notion of group rights in about 2 weeks when we have a whole session planned to discuss all of this, which is very relevant, much more extensively. A second differentiation can be made between rights that entail negative obligations versus the one that entail positive obligations. And I actually did already mention that in a previous clip, where negative obligations and the corresponding negative rights, so to say, entail that the state refrains from certain behaviors, such as, and we'll get to this in the video after, torture and inhumane and degrading treatment. On the other hand, there are rights that require the state to be a bit more proactive and to take active steps towards the fulfillment, which is usually the corresponding term used. And this is particularly true for social and economic rights, rights related to the economic welfare of persons, where obviously not doing something will not be sufficient for a state in order to meet needs related, for example, to healthcare, to food, to housing. In fact, there's often a direct connection made between civil and political rights, which are seen as sort of negative obligations, as opposed to economic and social rights, which are seen to entail positive obligations. Now, this has also been much criticized, and rightly so, because if you think about it for a moment, it's not all that simple. For example, ensuring the right to a fair trial actually entails the creation of a functioning judicial system, which entails high expenditures on the part of the state and really requires the state to take active steps to basically keep this system functioning and make sure, monitor that all parts and all employees in such a system do follow the general rule of providing a fair trial. Still, it's a distinction that you will see come back very often, so I don't want to dismiss it right out of hand. The conceptual utility of it is basically confirmed by the daily use, by practitioners, scholars. So yes, there are of course more negative obligations and more positive ones, but we need to be careful to assign them to specific rights and not to assume too much when we do that. The final category that I wanted to talk about here in this video is the notion of core rights. And here, quite deliberately, I want to take a somewhat different approach from the one given by Theo van Boven in the textbook, who starts off by pointing out that there are certain rights, such as the right to life or the prohibition of torture and inhumane degrading treatment, that can be considered core rights because they are more essential. I think that's not really very helpful as a sort of description, because as we saw, human rights are universal, interrelated, interdependent, and so on. So making these hierarchical distinctions is not in fact correct. In that context, it's indeed much more helpful to talk, for example, about Jus cogens rights, such as the prohibition of inhumane and degrading treatment and torture. So peremptory norms from which there's no derogation allowed, and I'll do that in the third clip. When it comes to the notion of core, it's rather, in my view, more helpful to think about the core of specific rights. So if we have a particular human right, we can think of it as implying some essential core obligations and other parts that are maybe also important, but not all that essential. And in the textbook, Theo van Boven actually does mention that and talks about comment 3 of the International Committee of Economic, Social and Cultural Rights, where it was pointed out with regards, for example, to the right to food, that things such as essential foodstuffs, indeed, something that provides for the subsistence, the minimum subsistence of a person, is indeed an essential component of a right, and something that arguably also you cannot derogate from as a state party. Let me end this clip by pointing out, and that's probably become obvious to you by now, that these kind of categories that I'm proposing here, that we are working with, are somehow overlapping or complementary. They just give us indeed different tools to understand, to get a better conceptual hold, as I said, of human rights. I'll now move more specifically to the notion of civil and political rights, and then in the third video, the right to be free from torture and inhumane and degrading treatment.